The order for complete estate settlement in probate court. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the SCAO form, State Court Administrative Order Form, PC 595. PC stands for Probate Court. And this is the order that gets entered at the conclusion of a formal hearing in which you've already filed a petition with the court. There's been a hearing on that petition asking the court to close the probate estate formally. This form is created and guided by various statutes and court rules. And at the bottom right corner, I've highlighted those statutes. It's really nice on these SCAO forms. They actually tell you the statutes and court rules that give rise to the creation of the form. So let's look at each of the statutes. The first one is 700.3952. And this statute provides that a personal representative can petition for an order for complete estate settlement at any time, but can't do so until at least the creditor period is expired. But it also provides that any interested party can actually ask for the closing of the estate. So not only the personal representative, but an interested party, an heir devizee within the estate, can actually make this petition as long as 1 year has gone by. In addition, it provides within that court rule 5.311 that the closing of the estate and the entry of this court order will terminate the legal responsibilities and duties of that personal representative and then ultimately discharge them of their legal obligations. So let's work our way through the entry of the order, or how this order gets filled out and completed after a petition for complete estate settlement has been filed with the probate court. At the top, it's pretty intuitive. You identify the name of the estate, of course, the date of the court hearing that would have been for the petition for complete estate settlement, and the judge that handled the matter. The next area is the area that identifies what the court found in that hearing. So for example, there's a variety of presets as well as some checkboxes. Let's work our way through them. Number 2 provides that notice would have had to have been given of the hearing on the petition for complete estate settlement to all of the interested parties, or it can be waived through a waiver and consent process. They can complete those waivers and consents and say, you know what, I don't need a court hearing. I'm consenting to the relief that has been requested in that petition. So sometimes the petition is filed with consents from all of the interested parties, and the court may waive the necessity for a court hearing and simply enter the order. But it's really an all or nothing proposition. If you have a few waivers and consents, and some people were notified through traditional mail under the court rule MCR 5.125, then of course there'd still be a hearing for those parties that did not have an opportunity to, or did not decide to consent to the entry of the order on the petition. Number 2 provides that the presentation of claims has expired. And earlier I mentioned that you can't file this petition until that 4-month creditor window has concluded. And that means that there's been publication, if appropriate, or the statute of limitations has expired for all creditors. So that period of time must have elapsed before the court is going to enter an order for complete estate settlement. Section 4 provides that if a final account was included in the petition, and it doesn't have to, the statute actually allows you to choose whether you want to submit a final account or not. But if you have brought one forth before the court will have then allowed the account, finding that it's correct and ought to be allowed. It's kind of an odd language to say ought to be allowed, but nonetheless, it is in essence saying that you are finding, or the court is finding, that everything on that account appears to be reasonable. Number 5 identifies that the estate assets have either been distributed and all claims have already been distributed, or you're going to do so after the entry of that order. And Section 5B is that provision that allows for the schedule to occur. So for example, you can have a schedule that says we're about to distribute to the following people under the will, or if there's no will, under the laws of intestacies. So it's going to identify the remaining assets and how you plan to distribute them. Section 6 identifies whether there's any Michigan inheritance tax or inheritance tax under the federal rules that is due. And 6B identifies that those are already paid in full. And then you provide evidence. Section 7 is if you've made a request within the petition to determine heirs. So often this is done at the onset when the first petition for probate is filed. You may be asking the court to make a determination of who the heirs of the estate are. But sometimes it's not done at the onset, and you may need either a redetermination of heirs at the end or an initial determination of heirs. So in this section, Section 7, you'd identify who the heirs are within the estate. Section 8 identifies whether there's a will or no will. We use the term intestate to identify when there is no will. And if there is a will, you could identify if you're asking the court to enter or admit the will to probate, that would be the provision there. But again, this is often done in the initial petition for probate, but sometimes it's done later on or as part of the final concluding order. The next section is the order section. This is after the court has made findings, the court has now entered orders, and it's a lot of repetition from what you just saw from above. 9 provides for if the person died intestate. 10 is if there's a will. 11 if you filed an account. 12 is if you've asked for fiduciary and or attorney fees within the petition. These would be identified if they're reasonable and they're allowed, or any exceptions to that. 13 talks about whether you've distributed. 14 provides that the personal representative's authority is then terminated. We spoke of that a little bit earlier. 15 provides for the discharge. This is the discharge of legal responsibility. 16 provides that if there is a surety bond or a bond, a personal bond that was required during the administration, that bond is now canceled. 17 provides for the estate now being closed. 18 provides that if you're going to be distributing afterwards, meaning after the entry of the order, then upon proof through receipts, then the court can enter a discharge. So, for example, sometimes there's more work to be done after that order, and the court would require receipts to be filed to then issue the discharge of the personal representative. And then 19 provides for the entry of the order for the determination of the heirs. The judge's signature indicating that they've entered that court order goes in the next section, and then if there's an attorney that prepared the form, the information would be contained there. So this is a really important document to use to conclude the probate administration within the probate process. At the Probate Pro, we're passionate about everything probate. If you have questions about the order for complete estate settlement or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.